And welcome to the discussion on the basic concepts and preliminary provisions of the 1987 Philippine Constitution. Of course, in our discussions, when we refer to the Philippine Constitution, we are talking about the 1987 Philippine Constitution. This was approved by the 1986 Constitutional Commission on October 12, 1986, and the 1987 Constitution of the Republic of the Philippines was presented to the then President Corazon Cojuangco Aquino, and it was ratified on February 2, 1987 by a plebiscite, and it was proclaimed to be in force on February 11, 1987. Now, the 1987 Philippine Constitution had a predecessor. Now, there was a constitution before the 1987 Constitution and after the 1973 Constitution. We had, of course, the 1986 Freedom Constitution, which was the interim constitution as we transitioned from the government of the then President Ferdinand Marcos and to the government of Corazon Cojuangco Aquino. So in that particular constitution, the 1986 Freedom Constitution, there was, of course, a provision there for the creation, and there was a mandate for the creation and the passage of the 1987 Philippine Constitution. Now let us consider some terms before we continue with our discussions. We define what political law is. Now, political law is that branch of public law which deals with the organization and operations of the governmental organs of the state and defines the relations of the state with the inhabitants of its territory. Actually, Constitutional Law 1 is the study of this particular concept, political law. So we will be studying with the organization and operations of the governmental organs of the state. Okay. So the first thing that we should consider is this particular term known as public law. Now, public law, as is defined, is the law or the laws that pertain to statutes that affect the relationship between the state and its inhabitants, vis-a-vis private law, which are laws or statutes that regulate the relationship between and among the citizenry, like commercial law, like civil law. Okay. So in this manner, in this particular definition, when we say the Constitution is a public law, then this is the relationship between the state and its people. Okay. So we define the Constitution. Now, the general definition for a Constitution is, according to Cooley in Constitutional Limitations, Constitution is that body of rules and maxims in accordance with which the powers of sovereignty are habitually exercised. But for our study, the authority for the definition of the Philippine Constitution is that given by Justice Malcolm in his book Philippine Constitutional Law. So the Constitution of the Philippines is that written instrument enacted by direct action of the government by the people, by which the fundamental powers of the government are established, limited and defined, and by which those powers are distributed among the several departments for their safe and useful exercise for the benefit of the body politic. Now, what are our takeaways in this particular definition? That the Philippine Constitution is a written constitution because it is a written instrument. Okay. Now, in the classification of constitutions, different kinds of constitutions, we have a written constitution and an unwritten constitution. Now, we say that the Constitution of the Philippines is a written constitution because we have one particular document. Okay, one particular document identified as the 1987 Philippine Constitution, as did we have the 1973, the 1986, the 1935, and the Malolos constitutions were all written constitutions. Now, in other jurisdictions, meaning in other countries, they have an unwritten constitution. Does that mean that it is not in writing? Of course not. Okay, the unwritten constitutions in these particular countries is that their constitution comes from different sources. So there is no one document which can be referred to as its constitution, but it is a collection of documents, instruments, laws, decrees, judicial decisions, no, upon which it establishes the fundamental powers of government. It establishes the fundamental rights of its people. So in essence, it is a constitution. Okay, but that is not the case for our Philippine Constitution. Now, another takeaway in this particular definition is that it is enacted by direct action of the people. Does that mean that every Filipino people or participated directly in the making of the Constitution, in its writing? Of course not. It is impossible for millions of Filipino people, no, to directly participate in that particular process. But I previously mentioned in the other slide of the 1987 Philippine Constitution having been presented to Cory Aquino and then presented to the people for a plebiscite, for approval. So the plebiscite is the direct action of the people. It was presented to the people for their approval. Okay. So in this particular definition also, the Constitution, okay, is where the fundamental powers of the government are established, limited, and defined. Okay, so it defines the powers of government. What are the limits, okay, of the exercise of such particular power? Okay. So an example of limitation to the fundamental powers of the state or of the government is the Bill of Rights. No, it limits the ability of or the freedom of government to interfere into the private affairs of its citizens in the exercise of their liberties and of their right to property. So that is a limitation established in the Constitution. Okay. So it also specifies how these particular powers are distributed among the several departments. Okay. And these particular departments, of course, no, if it is a fundamental learning in our undergraduate courses, no, in constitutional law, that we know these particular departments. We have the legislature, we have the executive, and we have the judiciary. And this, of course, is a definition by Justice Malcolm. As I mentioned, Justice Malcolm is an American jurist, no, who was appointed by the United States of America as a member of the Philippine Supreme Court in 1917, okay, until 1935. And if you would be reading several cases, no, some of those authoritative cases are written by one Justice Malcolm, referring to this particular individual. Okay. Yeah, you have to understand that we had American jurists in during the prior to 1935, because the Philippines was under the American rule. Okay. After the Spain ceded the Philippines to the United States in the Treaty of Paris. What is the purpose of the Constitution? The Constitution, no, is the purpose of the Constitution is to prescribe the permanent framework of a system of government. Now, a particular example of this framework of government is that the current government of the Philippines is the presidential form of government. No? In the 1973 Constitution, there was an experiment where we dabbled in a parliamentary form of government. Okay, so that is an example of prescribing a framework. Okay, so the second purpose is to assign to the several departments their respective powers and duties. Okay, so we will be discussing in our future classes and the future discussions. Now, what are the powers of the legislature, the powers of Congress? What are the powers of the judiciary? What are the powers of the executive, particularly the President of the Republic? And to establish certain first principles on which the government is founded. So when you say first principles, no, fundamental principles. Fundamental principles. And we of course know, no, that the Constitution being the fundamental law of the land, no, all other laws must bend to it, must bend to its power, must bow, no, to its provisions, no, that no law can be passed that is contrary to the Constitution. Okay, we now go to the classification of Constitution. We have written ones or unwritten ones. As I mentioned, no, written Constitution is where the Constitution exists in one particular document. It appears in one particular document. Okay, that is true to all of our constitutions. Of course, there are amendments that are incorporated, particularly in the 1935, in the 1973 constitutions. There were certain amendments, but it does not detract from the fact that it is a written constitution vis-a-vis, of course, an unwritten constitution where, no, as I mentioned, it does not mean that it is not in some written form or document. It is. But this particular document, no, is not in one particular form, no, in one particular document. It comes from different sources. So this, it is a what do you call this? A collection of documents, a collection of sources. So like in other jurisdictions, their sources of their constitution came from decrees of kings during their distant past. No, then it comes, no, parliamentary or legislative actions, legislative results or statutes, no, which become organic laws, okay, the fundamental laws of a particular land. But it is not purposely for it to be considered as one law, no. So this comes from, again, different sources. For example, also again, another source would be jurisprudence, no, decisions of the courts, okay, interpreting certain fundamental powers, fundamental rights, then incorporated together, they form a constitution. So the difference, written constitution, okay, is in a one particular document, an unwritten one comes from different sources. And this is very similar to the classification of a constitution being enacted or evolved, no? So enacted or conventional, again, similar to the written constitution, purposefully, no, this particular document was is came out, no, purposely to come out with a constitution, okay, a fundamental law. That is the purpose. But on the other hand, we have evolved, no, which is similar to the unwritten one, where it is an accumulation of different documents throughout the lifetime of the state, no, where it accumulates and to become a particular, no, to become a to be considered as a part of a state's constitution. Okay. Then we have rigid or flexible constitution. A rigid constitution is one, no, where amendments or changes in the constitution are difficult to be introduced because of certain formalities that are required to be complied with. Okay, a flexible constitution, for example, would be a constitution where amendments are easily introduced. No, the 1987 Philippine Constitution can be considered as one which is rigid. Since its approval in 1987, no amendments to the Philippine Constitution has been made. There were attempts not to amend the Constitution, particularly in extending the term of the president, but this has all failed. No? While a flexible constitution, an example probably would be the U.S. Constitution, where Congress can pass legislation in order to amend the Constitution. So that's why you will hear of the First Amendment, the Second Amendment, the Third Amendment, no, the Fourth Amendment. I think there are more than 20, or I think there are 26 amendments to the American Constitution. Now, of course, in our past, there have also been amendments to the Constitution. For example, in the 1935 Constitution, the term of the president was for a single term of 6 years. And then in the 1940s, there was an amendment to the Constitution which changed the the term of office to be 2 terms with 4 years for each term. Now, in the 1973 Constitution, there were changes. Again, primarily, according to some scholars, that the 1973 Constitution was purposely to allow the President of the Republic to extend his term despite the term limitations under the 1935 Constitution, because you have to understand that at that time, President Ferdinand Marcos was already on his second term, no? And nearing the end of his term, no, the 1973 Constitution was passed, which in the end allowed him, no, to extend his term until 1986, when he was ousted by a peaceful revolution, the EDSA revolution. Now, if there is no ambiguity, no, when the provisions of the Constitution are ambiguous, no, or it is susceptible to two or more interpretations, then we have to go to interpretation. Now, how do we interpret it? Does this particular provision mean this way, or does it mean that way? Now, of course, in interpreting laws, okay, you will be discussing this in your subject statutory construction, okay? And the first rule is that if the law is clear, okay, it is not necessary now to try to interpret it because it is clear. Okay, there is no ambiguity. If there's no ambiguity, then why construe? Okay. Oh, again, the term statutory construction, meaning, okay, the word is to interpret. How do you construe, okay, a particular term, a particular provision of law? So in statutory construction, in statutory construction, the first rule is that if it is clear, then there's no need to interpret it. But if there is ambiguity, there is an order of preference on how we interpret the Constitution. So primarily, the first of these rules is that the rule of verba legis, or the plain ordinary meaning first. No? So if there's an ambiguity of a particular word, then what is its plain and ordinary meaning in the context of the use of that particular language? Well, the problem here is that, of course, the Philippines, no, we are not native English speakers. Okay, although in our history, the English was was also a medium of instruction. It is also used, no, as the language of the judiciary, of the law. Okay, so it would be rare for you to find a law that is written in another language, even in Filipino. Or is it Filipino or Filipino? Okay, so verba legis. So if there's a term which is subject to possible interpretations, no, or several definitions, then how is this particular word used in that particular context? Okay, in its ordinary sense. Of course, when you are using a technical term, no, you use the technical term only if it is purposely used as a technical term. Okay? Pag ginamit if the word is used in its technical sense, then you define it in its technical sense. Okay. The English language, or the English language is quite peculiar because there are several words, no, that have several meanings. Okay, they are written similarly. They are read similarly, and yet they have a different meaning. Even the term, no, statutory construction. Okay, so interpretation of laws, statutes, construction, term construction, no, in an ordinary term means what? Not to build something. But in that essence, in statutory construction, that from the term construe, it it has a different meaning. It is interpretation. No, how is it used? Okay. The second mode is to determine the intent of the framers, ratio legis et anima. Okay. What was the intention of the framers in making use of this particular clause, making use of this particular term, or making use of this particular phrase in the Constitution? So, what is the intent of the framers? No. So, a guide probably would be the preamble of the Constitution, because the preamble, no, states the intention of the framers of the Constitution. So sinasabi doon ang kanilang intention on why they came out with the Constitution in the first place. Okay? So the intent of the framers. And the third one is the Constitution has to be interpreted as a whole. Okay? There's a Latin term there. I would butcher it if I would read it, but well, it's up to you to determine its proper pronunciation. But in the third order of the rule of interpretation is that the Constitution has to be interpreted as a whole. No, so you take the whole document itself. So similar with taking the intention of the framers. No, so you refer what taking together the other parts of the Constitution. Okay, it could mean that this particular term is also used in other parts of that particular document. Okay, so we determine it in the context of taking and interpreting it as a whole. No, so we take into consideration the whole Constitution itself. And then another manner by which we interpret the Constitution is by having to refer to the records on the debates in Congress. Okay. So tingnan natin, what were the debates in Congress when they were coming out with this particular provision of law? What was their intention? Okay. So what are other means of interpreting the Constitution? No? So one is, in case of doubt, the provisions should be considered self-executing. This means if that there is a doubt as to whether we would consider a provision of the Constitution as self-executing or non-self-executing provision, we should resolve it in favor of it being self-executing. What do we mean by self-executing provisions of the Constitution? No, that there is a need, there is no, it is not necessary for the passage of an enabling law to make that particular provision of the Constitution effective. Like under the Bill of Rights, no, the freedoms and that has been established under the Bill of Rights need not have to have an enabling law in order to be effective. So when our particular rights have been violated, then we can go to the Constitution directly and say these are my rights. No, kailangan pa bang gumawa ng additional laws in order to make it effective? No more. Okay, these have been provided under the Constitution. And on the other hand, a non-self-executing provision of law or of a Constitution requires an enabling law to make it effective. Now, an example would be in the state policies and principles, where there is a prescription against the establishment of political dynasties. And of course, we have a common understanding of what political dynasty is, no? Because we see it in our own, in the politics of our own local governments, in our own localities, where the mayor, the vice mayor, and the members of the Sanggunian are all related. So sasabihin natin, oh, political dynasty yan. But, okay, the Constitution does not define what political dynasty is. And therefore, it cannot be a source of a prohibition against this kind of politics, where people of that are closely related by blood and by affinity, no, sit in government offices. So, and that is why until now there is no law, no, that or there is no prohibition against that particular kind of politics, because there is no law that prohibits it. And that is an example of a non-self-executing provision of the Constitution. Nandoon sinabi niya na bawal ang political dynasty. But what is political dynasty? That is the question. Okay? Until a law is passed that defines political dynasty and prohibits it, then we do not know. Okay? We do not know. Okay? So that particular provision of the Constitution is a non-self-executing provision. Essentially, nearly all of the state policies are non-self-executing provisions. They are merely guides for Congress when they make laws, with the exception, of course, no, of that particular provision on the environment, where there is no enabling law, and yet the Supreme Court has stated that the future generations, no, have the right to raise the question of or that any person, even minors and of people of future generations or those affected in the future, can raise the issue and file an action for the preservation of the environment. Okay, there was no enabling law, and yet the state recognized the right of those particular individuals. If there is a question as to whether the provision is mandatory or merely directory, then we opt for it being interpreted as mandatory. Okay, so mandatory instead of directory, and prospective rather than retroactive. Okay, so it leans more to prospectivity, and the application to those instances that occurs after the passage of the law, and it does not apply to those instances that occurred previously, okay, before the passage of the Constitution. So, prospectivity over retroactivity. So let's have a little history, no? A history lesson. The study of the Constitution is actually a study of history. Why do we say this? Because, you know, laws are actually reactions of to the current situation of a particular society. Although there are concepts which states that a constitution should be a living document, know where it can apply not only in the past but also into the future. But inevitably, of course, now there are certain situations where certain provisions in the past could not be applied in the future. Uh, this is more. This is really more applicable now, no? Considering the fast advancements of society in technology, okay, particularly in technology, in business, in commerce. Okay, the law is slow in uh, in dealing with the new issues that arise as a result of new technologies. No, bioethics, for example, biotechnology. Okay, and of course communication. Imagine that. Well, let's have a some discussion here. No, uh, in to have a little context, we look at the American Constitution. No, the amendment to the American Constitution and the establishment of the right to bear arms. So under the American Constitution, every citizen has the right to bear arms. Now, that is a contentious issue in the United States, and that's why the passage of gun control is limited in the United States because of that particular constitutional provision. But you have to consider that that particular amendment was done at a time now when the United States was like the wild frontier, no? So it was in the 1700s, or the late 1700s, no, where America was a wild country, and there were atrocities being committed by uh, the British and committed by other people, and that's why, in order to defend themselves, the right to bear arms was given to the people. No? The creation of the militia. Okay, but until at this moment, no, at this moment in American history, okay, uh, that particular interpretation of the Constitution has been lost. Okay. So at any rate, no, on our own turf, we discuss the history of the Constitution. So there were several Philippine constitutions. No? To start off, no, we had the 1899 Malolos Constitution. This was the constitution under the republic established by then President Emilio Aguinaldo. Okay, that was established after the Declaration of Independence of the Philippines. Now, the Malolos Constitution basically was patterned, no, um, on the Constitution of Cuba, okay, and other European nations. It's unfortunate that the 1899 Malolos Constitution did not have a long life, as the Philippines, no, after the declaration of the independence was taken over by the United States of America. Because in history reminds us that the Philippines was ceded to the United States by Spain through the Treaty of Paris after Spain has lost in the Spanish-American War. And what happened was this particular constitution and the government established by Emilio Aguinaldo was abolished. So with the Americans came the American rule in the establishment of the Philippine Assembly, which was the lawmaking body in the Republic of the Philippines. No, in the Philippines, because we cannot consider ourselves already as a republic, as an independent state, because we were under American rule. And when we were under American rule, the basic laws of the Philippines can be found in several instruments, and some of these instruments are the Jones Law of 1916 and the Philippine Organic Act of 1902. Now, the Jones Law of 1916 and the Philippine Organic Act of 1902 are legislative enactments by the United States Congress. Okay, so it only manifests that we were under the rule of the Americans. And in these laws, no, we were under governor generals. Okay, and of course, but in this particular laws, it was the promise of the establishment of an independent government for the republic. Particularly with the passage of the 1935 Constitution, there was already a promise that the Philippines will gain independence after 10 years after the 1935 Constitution. Okay. Now, what are some of the effects of the 1935 Constitution? It established the office of the president and its term. Okay, the term of the president under the 1935 Constitution was 4 years, with the possibility of being reelected for a second term. So a president can stay in office for 2 consecutive 4-year terms. And under the 1935 Constitution, it also now limits the membership to the Philippine Supreme Court. And that is why Justice Malcolm, who was appointed as a justice of the Supreme Court in 1917, had to retire in 1935 because the 1935 Constitution requires that the justices of the Supreme Court must be Filipino citizens. Then comes the Second World War, and we were under, again, another foreign power. And in this instance, we were under Japanese rule. And under Japanese rule was the establishment of a different form of government. Okay, and the establishment and the promulgation and the passage of the 1943 Constitution. Okay, which, of course, came to an end when the Japanese surrendered. And this brought into effect again, re-established the 1935 Constitution. Then we acquired independence on July 4th, 1946. Okay. So from the end of the Second World War, the re-establishment of the Philippine Republic until 1973, okay, we were under the 1935 Constitution. So it allowed re-election for presidents to a second term. And then in the 1973 Constitution, according to scholars, the 1973 Constitution was a plan by then President Marcos, who was at the end of his term, of his second term, nearing the end of his second term, came out with the martial law and the passage of the 1973 Constitution, which allowed him to stay on as the President of the Republic until 1986. Okay. The 1973 Constitution also abolished the bicameral Congress into a unicameral legislative body known as the Batasang Pambansa, or again, the National Assembly. And after the 1973 Constitution was mired in controversy, also because of the manner by which it was approved by the people. It was ratified by the people. So what was the story? Well, apparently, by decree, the president stated that or directed that the ratification of the 1973 Constitution will be made in assemblies throughout the entire Philippines, and to be by viva voce manner of ratification. Okay, so apparently the question was raised to the people and say, sino ang may gusto ng bigas? And they raised their hands, and that was counted already as ratification. So that was the controversy of the 1973 Constitution. When President Marcos left the Philippines in 1986, okay, by a peaceful revolution, Corazon Aquino came into power, and of course, it now abolished the 1970. They now abolished the 1973 Constitution, okay, and established a freedom constitution by presidential proclamation. This is known as the 1986 Freedom Constitution. Under the 1986 Freedom Constitution, the president still had legislative power through executive orders and presidential proclamations also. In the 1973 Constitution, the president exercised legislative power in the form of presidential decrees. Okay, presidential decrees. So the president can enact laws, okay, through a presidential decree. In 1986, the president, under the 1986 Freedom Constitution, the president was also given legislative powers. But in this instance, instead of presidential decrees, it is through presidential proclamations and executive orders. An example of this executive order was the Family Code of the Philippines, which was an amendment to the Civil Code, okay, the Civil Code of the Philippines, particularly on family relations. By virtue of Executive Order 209, the Civil Code was amended. Okay, but with the 1987 Constitution, Philippine Constitution, this particular lawmaking powers of the president were restored to the Congress. So at present, the current president can no longer amend laws, okay, by virtue of executive orders. But the presidential executive order and proclamation have the force and effect of law for as long as it is not contrary to law. For as long as it is granted by law and it is granted by the Constitution, okay, and in order to make it, in order to give power, or in order to give, to establish procedures by which it will be imposed, no? The president is granted these particular powers of issuing executive orders and presidential proclamations. So that in essence is a short history of the Philippine Constitution. Now we come to the preamble of the Constitution. The preamble states, "We, the sovereign Filipino people, imploring the aid of Almighty God, in order to build a just and humane society and establish a government that shall embody our ideals and aspirations, promote the common good, conserve and develop our patrimony, and secure to ourselves and our posterity the blessings of independence and democracy under the rule of law and a regime of truth, justice, freedom, love, equality, and peace, do ordain and promulgate this Constitution." So what is the significance of the preamble? Well, the preamble actually states who the authors of the Constitution are, no? Who are the authors of the Constitution? So the first statement, we, the sovereign Filipino people. So the authors of the Constitution are the Filipino people. And of course, the preamble is a manifestation as to the intention of the framers of the Constitution. Okay, so it gives the intent and purpose of why the Filipino people came together to come up with the Constitution. But is the preamble a source of right or a source of obligation? It is not, no? No rights are established, no obligations are established under the preamble. At any rate, what does preamble mean, no? Preamble. No? To amble is to walk. So a preamble is literally means to walk before. So it is actually a foreword to the Constitution. So to repeat, the preamble is not a source of right, nor is it a source of, nor does it create obligation, but rather its purpose is to state the authorship of the Constitution and the intent for which they established this particular Constitution. So that ends our discussion on this particular topic.